Division 1 is now in session.
Thank you. Please be seated. Good morning. We are on the record in CV20 0342 Truck v. Texidor. This is the date and time set for oral argument. Counsel, these proceedings are being video and audio recorded and live streamed. So we ask that you please identify yourself and your client at the beginning of argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock if you'd like to reserve some time for rebuttal. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Thank you, Your Honor. Your Honors, good morning. Thomas Dixon for La Patisserie Bakery and the Texidor family, who are the appellants. May it please the court, I'd like to reserve at least 3 minutes for my rebuttal. When Truck Insurance sold La Patisserie a package of insurance protections, it called it a manufacturer's policy and marketed it as being specially designed to protect against risks unique to the manufacturing process. La Patisserie suffered a manufacturing loss to its manufactured product, which was bread, and it in fact triggered 2 coverages under that policy. The bread became contaminated with metal that triggered first-party coverage for the food contamination. Food contamination is not an excluded risk under this all-risk policy. The bread did not wear out. It became contaminated with metal from an external source, and that triggered first-party coverage. The second loss that was unique to the manufacturing process was a loss that occurred when that bread was shipped through a distributor strictly from scratch to Walmart stores, who incorporated that bread into their sandwiches, causing a property damage loss to Walmart property. La Patisserie became liable for damages because of that property damage under the liability policy. That was a second coverage trigger that comes straight from the insuring agreement and the liability policy. Truck failed to process and pay either claim, and La Patisserie lost all of its business assets in a foreclosure action to collect on a $1.3 million judgment in favor of the distributor strictly from scratch. The trial court here recognized that incorporation of bread into other property was a covered property damage loss under the liability policy, but dismissed that claim because our adversary did not, in the trial court's view, adequately plead the factual basis for the claim it was making for the resulting property damage. The only claim we were allowed to present to the jury was the claim arising out of the first-party coverages for food contamination to our own product. That's the claim that the trial court wants to try again because it found the verdict excessive. I'd like to address the new trial order first because I think I can do that briefly before I proceed to the liability claim dismissal. New trials are a remedy that is to be used sparingly when a jury hears evidence it shouldn't have heard or is improperly instructed under the law of this state. Trial judges have broad discretion to grant new trials when those things occur, but those things did not occur in this trial. The jury received evidence without objection on consequential damages for breach of contract in excess of $8 million for the loss of the building and improvements as a consequence of the failure to pay the first party loss. And the judge properly instructed the jury using a stipulated instruction, Raji Contract 18, that it could award those amounts as consequential damages for breach of contract. There was no objection made to the form of that instruction, and the jury was properly instructed based on another stipulated verdict form that the consequential damages could overlap with bad faith damages, that it could award those under either theory of recovery, but not both. So I asked the court, what will change What would change if we retried this case? The jury was properly instructed. The evidence came in without objection. The trial court was concerned about the closing argument. The advocacy in the closing argument was consistent with the overlapping damages instruction that was stipulated to. It was consistent with the distinction in the jury instructions between direct policy damage, direct contract damages, which are the policy benefits, and consequential contract damages. But even if it wasn't, even if there was something in that closing argument which we don't concede that was inconsistent with the instructions that were set to give to this jury, Truck had an obligation to object either after closing or after the verdict. Truck has an obligation to stand up and say that the argument that was made here is inconsistent with the way that we've agreed we're going to instruct that jury. You've got to instruct the jury that they cannot award consequential damages for the loss of the building and the loss of the property. And if they don't do that, that is waived. This panel, 2 years ago, in the Miller versus Hill case, this panel correctly quoted the Trustmark case that a party, by failing to challenge the verdict when it is rendered, waives their objections to any error. So if the verdict comes back and the jury has found and awarded consequential damages for the loss of the building, and Truck believes that there's an objection because they haven't found bad faith, that's curable at that point. This court has found, the Trustmark court found, silence is waiver if you don't stand up because it could have been corrected. Our position is that the jury, there was nothing to correct. The jury was properly instructed, but there is absolutely, the taxpayers of this state are not required to pay for another month-long trial if this insurance company doesn't preserve its objections as the law of this state provides, and they did not. Let me make a fast segue to the liability claim. There's one thing, and you'll be surprised that there's anything that the parties agree on here, and that is that there is an overriding threshold issue of law that the court must address before diving into the evidence on the claim handling on the liability claim. Truck says that the fair claim handling standards that have been established in cases like Zillich and Rawlings and Deese, that those standards do not apply to claims arising under liability policies. Your Honors, prevailing on that argument is the only pathway that allows Truck or the trial court to bypass all of the issues of fact as to how Truck investigated this claim, as to the concealments and misrepresentations, pre-litigation before there was ever a complaint to review, its misrepresentations in its denial letter that it had reviewed everything without telling my clients that had not, and all of the evidence from which a jury could infer bad faith after the denial. This issue has been decided in the Lennar versus Transamerica case. This division of this court held in a liability claim where the carriers were denying coverage just like Truck was, and the carrier said, we had no duty to investigate this claim once we had made our coverage denial. This court said no, and it looked to Zillich, and it looked to Deese to determine if there were issues of fact that could only be resolved by a jury. And in looking at Deese, this court held that a liability insurer cannot reasonably and in good faith deny payments to an insured without thoroughly investigating the foundation for its denial. No court has ever held that the fair claims handling standards that apply to health insurers, that apply to life insurers, that apply to property insurers, that those standards don't apply to liability insurers. This court either has to overrule Lennar and remove the concept of fair claim handling, fair and thorough investigations as a duty that applies to liability insurers. It either has to overrule it or it has to send this case back to the trial court and allow a jury to resolve those issues of fact. Why would it make any sense to hold that liability insurers don't have to thoroughly investigate claims, that they don't have to act honestly and give equal consideration to their insured and not misrepresent the fact? Why would that make any sense?
Let's talk about that. Why would that make any sense? Who has the duty to bring the information regarding the claim to the insurance company?
Great question, and let's apply these to that standard. What does the insurance company have a duty to do? It has a duty to reasonably and in good faith thoroughly investigate the claim facts. Now look, there are...
So I'm the insurer. You bring this basket of facts to me. I sort through it, and I say, you're not covered. They have a duty independent of that to go out and investigate?
Absolutely, they have a duty. They have a duty to investigate.
Lennar says that duty is triggered once the insurer or the insured makes a factual showing sufficient to trigger coverage. So, how does that duty apply if you present information that says you're not covered?
The information that my client presented is that we ship bread, that the bread is used and incorporated into sandwiches. Truck was presented with a complaint.
You said we would have to overrule Lennar. Lennar says once information is presented that shows coverage is triggered, then they have a duty to investigate.
Well, Lennar does not say that. Lennar says
I'll read it. Once an insured makes some factual showing that the suit is actually one for damages resulting from events that fall under policy terms, an insurer has a duty to investigate those facts and provide a defense.
So the showing that was made is that this claim that my clients shipped bread product that was contaminated, that was incorporated into sandwich materials, that is the facts that triggers coverage. So let me ask you this. Let's take what's undisputed. The evidence was that Truck knew at every stage of this claim, Truck knew that the incorporation of contaminated bread into other materials causing property damage would be a coverage trigger. Truck knew that sandwiches were thrown out, so the question is, if you apply these to that does Truck then, from what it knows, have a duty to reasonably in good faith investigate the basis for the coverage denial? Does Truck have an obligation to say, if we know that sandwiches, that contaminated bread was incorporated into sandwiches, we know that it was thrown out, those facts have been presented to us, does it have a duty to investigate what claims are being asserted? And particularly, even if it doesn't come to the game with the duty to investigate that, Judge, what if they promise they will? Does that trigger? What if they promise the insured, we're going to get these documents before there's ever a complaint to review? What if, this is our facts, what if they promise the insured, we're going to get those we're going to obtain those documents and we're going to review them for coverage? And they don't ever tell my client, we didn't do that. What we promised we would do, we didn't do. can they shift the burden to my insured if they misrepresent what they're going to do and they conceal the fact that they didn't do it? Can you shift the burden to my clients who are immigrant bakers? They don't know what facts are going to trigger coverage. They don't know that it's the incorporation of that bread into sandwiches that's going to trigger coverage. It's truck that knows that. So how does it make sense under those facts? It's a fact-specific inquiry as to whether it is reasonable under these circumstances. The cases that you're looking at, yeah, there are in some facts that if all the insurer is presented with is a complaint and there's no other information available, it's not reasonably ascertainable. That's what the Kepner case, is it reasonably ascertainable, or are there other facts known?
Reasonably ascertainable from the facts presented to the insurer.
Yes.
Okay.
Right. But it doesn't say that it has to come out of the
I'm
mouth
just trying to
of
clarify, because you said earlier that Lennar triggers an independent duty to investigate, and I agree with you, but you've omitted the part where once facts are presented to the insurer.
So that's right.
sufficient
Okay.
coverage. That's all.
Yes. So the facts that are presented and what truck knows, all that is the context for whether is there an issue of fact here as to whether truck acted reasonably under the facts of this claim. And truck knows that if you apply the rules of the road of Deese and Rawlings and Zillich, if you apply it here, there are issues of fact. I could spend another hour that I don't have talking to you about all the issues of fact, whether it was fair, what they did. After the claim had been denied and they hired Ms. Sluga, who was a trial witness here, who testified in her deposition that I knew, and I told truck that if incorporation occurs, that's something we have to be on the lookout for. That's facts that she knew, and she reported them to the very claim adjuster who said, I knew they threw out bread, in her deposition. Does that create an issue of fact? That's facts that were known and admitted in depositions. We knew these facts. Does that create an issue of fact for a jury to decide, was this fair to not? Ask the doggone question. Is there any claim being made against this insured who we have to treat fairly for damages that arose out of the incorporation of this? Just ask the question. Or at least, isn't it fair to at least tell the insured, geez, we know that there's this coverage. You should be on the lookout. Is there an issue of fact as to whether once they said we should be on the lookout for this, that they acted reasonably in doing all the things they could if they were really on the lookout? All those are issues of fact for the jury. And that's why this has to go back to the jury to resolve those issues of fact. It cannot be resolved as a matter of law that this was fair claim handling under the evidence that we presented. And that issue, this has to be remanded back so a jury can resolve those issues of fact. I'll reserve my 2 minutes.
Thank you, counsel.
Good morning, Your Honors. May it please the Court. My name is Gina Sluga, and I represent Truck Insurance Exchange. The record in this case has admittedly gotten very cluttered with reams of paper, but the relevant facts are actually pretty straightforward. On the liability side of this, the relevant facts are those that were known to Truck at the time that the complaint was filed and that the lawsuit was actually pending. There's been a lot of fast and loose here with the temporal timeline. This case has been around for 5 years. And so you're hearing a lot of things about what Truck knew when. We're going to break that down. We'll look at the evidence of what Truck actually knew when, and we'll talk a little bit about the citations to the record you've been given now as evidence of what Truck allegedly knew during the time that the underlying claim was pending. The issues on the property claim are actually also pretty straightforward. law patisserie was permitted to introduce a great deal of evidence at trial that really probably would not have come in. And we have this from statements from Judge Smith in the transcript of the record, had it not been for an agreement of counsel. Mr. Dixon agreed that with respect to the consequential damages that his client was seeking, that those were, in essence, bad faith damages. Not an unreasonable proposition if one looks at the revised Arizona jury instructions, the Rajis, on bad faith. The comments to the bad faith Rajis use the term consequential damages 6 times. In the context of a claim against insurance companies, consequential damages are bad faith damages. You can get them if you can make a showing of bad faith. That's what everyone understood here. That's how the case proceeded. That's how the jury instructions were formed. That's how closing arguments proceeded. And then when the jury here found there was no bad faith, this is just a simple breach of contract action, the jury then got confused and issued an award that Judge Smith, in his sound discretion as the trial court who presided over all of these proceedings for years, made very clear in his minute entry order could not be supported by the evidence or by the law.
Did you ask for a remitter in your motion for new trial as an alternative basis?
We did. There were several motions
Why didn't
filed.
Judge Smith, because this seems like, it seems weird, and I'm not second guessing his wisdom on this, but it seems weird to do a remand and try it over again when it's a damages issue. Is there anything in the record that we can explain why this was the result as opposed to just remitter?
What you can look at in terms of the answer to that question is only going to be reflected in Judge Smith's order, which is at index of the record 734. It's his minute entry order dated May 18th. And yes, you've actually gotten right to the heart of one of the issues on our cross appeal. We have asserted that there is no need for this case to be retried. If you look at the re-urged Rule 50 and the Rule 59 motions that were filed post-verdict, we asked for a couple of things, and we gave the court, and I'll reiterate for this court, a variety of ways in which we can fix the problems that occurred below. And one would be to simply have granted the Rule 50 motion for judgment as a matter of law, because again, these consequential damages were not available in the context of a civil breach of contract. That is one way that it could be done. Another would have been through Rule 59 motion, again, after post-judgment, to have granted the motion for remitter, and just this court can find that it was error to not grant the motion for remitter and just enter judgment in the $252,000 amount stipulated to by the parties as the appropriate damages for the bad faith claim. There's been a lot of discussion this morning from counsel about what...
You said bad faith. I assume you meant contract.
I did. I apologize. Thank you. That all of the rest of this was bad faith. The jury has already found for us there was no bad faith. And to that end, you've heard a lot of discussion this morning about what this case is really about, is whether Truck was reasonable in doing this or reasonable in doing that. That is categorically not what this case is about anymore. It was for a long time. The insureds brought forth a lot of claims styled as bad faith claims because at the end of the day, the claims weren't covered. And so they had to package those arguments up in some way. They called them bad faith. But the trial court granted summary judgment first on the issue of whether there was bad faith in the handling of the liability policy. That came off the table. Court order was clear. We have that at record 253. And then again, when Judge Smith indulged the motion for reconsideration that was based on evidence that could have, indeed probably should have been generated by the insureds earlier on, he still considered it substantively again. That's index of the record at 446. Not once, but twice, he affirmed all of that. The jury is
we review that de novo. Your brief's a little confusing on the standard of review.
With respect to the grant of summary judgment and the legal issues presented, absolutely it is a de novo standard. But we're going to...
So why did Judge Smith get it right? I mean, they point in their briefs to a bunch of facts that seem to be contested. Tell me where they're wrong.
The good news is he broke it down for you in great detail in those orders that we've already cited. He walks you through it very nicely. But I'm happy to do it again today. Again, let's focus on what the relevant evidence is. We've got the complaint, which was actually very difficult for Truck to get a hold of. You'll see in the record that Truck had to actually implore the insureds multiple times over, would you just send us the complaint? We've got the denial letter, the letter that explained this isn't a complaint that alleges property damage, but if you have additional information, come forward with it. Give it to us. Just as you have made very clear, Judge Morse, the Lennar Court does require citing decades-old authority first articulated in the advanced roofing v. USF&G matter. Counsel this morning talked about how his clients were unsophisticated and perhaps couldn't have known, but they had lawyers. They had 2 different lawyers who represented them in the course of the underlying proceedings, and they had a first coverage lawyer who represented them even before Mr. Dixon. Any one of those lawyers, if the information was in the record and available, could have brought it forward, and they didn't. It was La Patisserie's 4th lawyer, Mr. Dixon, post-judgment, who first came forward with some of the theories that we're now looking at. Let's look now at the record. What is in this record? If I'm suggesting to you that those 4 documents are really what
Let
matters.
me stop you for a second.
Of course.
Because it strikes me that the duty to defend should, providing information after the underlying litigation is ended seems to be different than providing it before.
It's absolutely different, and
But I don't find case law that really makes that distinction, at least clearly. Is there a good case for it?
Yes, the Salvatore case, and I'm looking in my notes to give you the factual site, that is 133 Arizona 16. Specifically, if you look at page 19 of that opinion, what happened in that case is complaint was filed. Like here, the complaint did not on its face state a covered cause of action, and the carrier denied the claim. The insured entered a dam-run agreement. Plaintiff then tried to execute that against the carrier on the basis of an amended complaint and new facts that had not been presented to the carrier while the case was pending. The court said absolutely not. The law is clear, I quote now from the Court of Appeals opinion, the law is clear that an insurer must be given notice of an amended pleading which would impose a duty to defend. Failure to give notice would relieve the insurer of liability under the policy. Here, although the denial letter explicitly asked if there's an amended pleading, would you send it to us? Didn't happen here. But the other thing that happened in that case, they talked about other claims from outside the record. That was in the Salvatore case. And the court said if the insured knew of such claims, again, claims extrinsic to the complaint, and did not notify the carrier, and instead entered into agreements that permitted plaintiffs to get judgment for claims never alleged in the pleadings and never disclosed to the carrier, the court said a clearer miscarriage of justice could not be shown. Again, that's at page 19 of the Court of Appeals opinion in that case. That's what we have happening here. We have a version of this case that was never put forth in the pleadings. Throughout this record, in the opening brief on appeal, when La Patisserie says time and again, the complaint here stated a covered cause of action, it stated a claim for the sandwich damages, I'd like to encourage you, or perhaps more to the point, some of your bright young clerks, to look carefully at what they're citing in the index to the record site. They are citing index to the record 315. What is that? That is La Patisserie's statement of newly discovered facts in support of a motion for reconsideration filed in 2019. Not the complaint. The complaint doesn't state a covered cause of action. Not any of the briefs to the trial court on summary judgment on this issue. After they'd lost the issue, they ran around and got a lot of affidavits and declarations of people who'd been deposed, by and large, for the most part. The depositions didn't say anything like this. But now we've got this new collection of affidavits. After they'd already lost summary judgment, they presented them to the court, newly discovered facts in support of motion for consideration. Things like an affidavit from Scott Freeman, the Fenimore Craig attorney who drafted the complaint that doesn't state a covered cause of action. And in his affidavit, he said, you know, I really meant for it to be broadly worded and to bring forward any claims that might be out there. That is a far cry from suggesting that the complaint in this matter triggered a duty to defend. And it is about the complaint, and it needs to be, and that is based on Arizona black letter insurance law that has been around, Your Honor, since literally before I was born, and I'm not that young. Kepner, the Kepner decision, undisturbed authority from the Arizona Supreme Court, says it is about the complaint. That is where you start in looking at the duties. Now, what about this idea of, well, before the complaint was filed, there's some things in the claims notes. those don't trigger duties. The policy itself is clear on that. The carrier has the right to investigate claims. It has the duty to defend covered suits. It is the complaint, it is the suit that triggers duties. And that makes sense. When something happens, when an occurrence, the word we use in the insurance industry, when an occurrence takes place, the policy expects that the insured is going to give notice of that occurrence to the carrier. You don't know what's going to come of it yet. Insurance companies receive notice of claims that don't result in lawsuits all the time. You open a file, you take a look at it, you see what comes. There's this implication here. When I mentioned there's a little bit of fast and loose happening with the timeline, there's this suggestion as though there was all of this time and opportunity available to Truck to investigate this claim between when that first notice of claim came in and when the complaint was filed, that there's some sort of unreasonable behavior. The first notice of claim came in on May 20th of 2014. That was a phone call from La Patisserie's insurance agent, Kara Ansbach. She called and she said, hey, my client bakes bread for Walmart. Walmart found some metal in the bread. The metal was discovered before any of the bread made its way to customers, but this happened, there might be a claim. 3 weeks later, on June 11th, is when the complaint is filed. 3 weeks. During those 3 weeks, if you look at the claims notes, what you'll see is multiple times where the carrier tried to get a hold of La Patisserie, couldn't do it. Mailboxes were full, got a hold of one of the family members, but was told, no, you got to talk to a different family member. Gets a hold of that family member, she says, we don't know what Walmart's going to claim yet, so just hang on a little bit. 3 weeks later, the complaint is filed. When Truck gets the complaint, again, let's be clear, it's the only version of the complaint they ever got from the insured. Did not state a covered cause of action. It did not state a claim for damages because of property damage. Now, you heard this alluded to briefly in oral argument this morning. You're going to see it in particular in La Patisserie's reply in support of their appeal. This idea that, you know what, this whole sandwich damage thing, you don't need to worry about the sandwich damages. We only need damages because of property damage. That's what we need. We don't need the sandwiches at all. And the tomatoes and the bologna that Walmart had to throw away without ever putting it in a sandwich, that's good enough. Or the labor charges that Walmart charged for, that's good enough. Absolutely is not. Number one, this is a new issue. It wasn't raised to the trial court. It wasn't raised in the opening brief. It is waived 2 times over. Secondly, it's just wrong. Judge Smith touched on this. You see this in particular indexed to the record 253, the July 25th, 2018 order on the first time he considered the motion for summary judgment on the liability claims. Most of those other damages that were out there would have been excluded damages, excluded by a couple of different exclusions. One in particular, the recall exclusion. Another, the impaired property exclusion. The policy expressly, exclusion O, it precludes coverage for damages claimed because of a loss, cost, or expense incurred by you or others for loss of use, withdrawal, recall of products. Not covered. Those damages weren't. It was clear throughout the underlying record at the trial court, the only way to have a claim that came within the insuring clause, it's got to be a claim for damages because of bodily injury, and thank goodness no one was hurt, no one ate this bread, or property damage. And they can't be excluded. And the only category of potential damages that fit that bill throughout the record, the sandwiches that are a myth. Walmart never brought a claim against La Patisserie. Walmart never made a claim. They never sued anybody. They told their wholesaler, make this right. Pay us back our economic losses. And valuing their relationship with the nation's largest retailer, strictly from scratch, said, yes, sir. They filed a suit against La Patisserie for what they could claim back as damages. And as it turned out, it was their economic losses that they themselves could prove without a Walmart witness. There's none in the record anywhere. Without a Walmart affidavit, not even a custodian of records of Walmart provided documents. Walmart is a myth. They are absent from this case. These damages are a myth. The sandwich damages would have been the only way into coverage here, and they didn't exist. Any argument to the contrary now is wrong. and it is also waived 2 times over. At this point, I would like to reserve my remaining 4 minutes for our rebuttal on the cross appeal. Thank you, Your Honor.
Thank you. Counsel, you got about 2 minutes.
Judge, I want to seize on the response to your question where Ms. Sluga says that all this messy business about promising that we, pre-litigation, before there's a complaint to review, promising that we'll get those documents and we'll review them for coverage, and then never telling my clients that they didn't get them, instead saying we reviewed everything. What did she say? That doesn't trigger any duties? Well, I'm anxious for this court's decision on that. Is that the law in this state? That the investigation, the promises you make to the insured, that whether you misrepresent, whether you conceal, whether you tell insured you'll do things and you don't, that doesn't trigger any duties. We have no remedy for that before there's a complaint. In the state of Arizona, there is no remedy. You can be as deceitful as you want as an insurance company, and it doesn't trigger any duties. That's what this is about. If she's right, then your opinion has to write a whole new set of rules for liability insurers that's different than any other insurer in this state. And there's no court that's ever done that. Lennar didn't do that. No court has ever said that. There's no basis for this court to do it. Judge Morse, I do want to respond to your question about is there any good case law about notice that's received after trial. I do agree that it's different, but the section on pages 57 to 59 of our opening brief does cite some cases that are instructive on that issue, that says even if it's after, you still have an obligation to consider it and respond fairly. I've never understood, whether they knew we're on adequate notice or not, why they don't have an obligation once we've given notice that there was a covered claim now. It's never been explained and wasn't in the trial court why we wouldn't have an obligation even now. The statute hasn't run. So that would be, take a look at those cases. I think they are instructive on a small part of the case.
Thank you, counsel. Got 4 minutes for rebuttal.
Your Honor, specifically with respect to the cross appeal, you touched on this earlier when you asked, do we really even need the new trial? And there, again, we do not. The consequential damages is one issue that, despite the volume of this record, really wasn't adequately briefed. And the reason why is this is a brand new
And it
theory.
wasn't really adequately raised before the trial court, because you were proceeding on a basis, as you talked about earlier, about consequential being tied to bad faith.
Yeah.
But the trial court wasn't really presented with a clear opportunity to rule on how else consequential damages may be applied, right?
That's exactly right. And even before that, I'm going to dial back to the time
Which
even
actually,
farther.
I think, supports the notion of denying the remittitor and possibly granting the new trial, is that we should let a trial court address these issues in the first instance.
If you believe that there's a basis in the law for doing so, there isn't. Let's walk through it. These damages, the loss of the kingdom, as Judge Smith referred to them, the loss of the bakery, were first styled as damages flowing from the denial of the liability claim. And in that context, they made some sense. The bakery was lost because it was seized to pay a judgment. But the judgment wasn't covered, the liability policy wasn't triggered, that claim wasn't out there. So hedging their bets, they then styled it as a property damage claim. You will see in the record, indexed to the record 253 summarizes this, but for the proof of loss itself, that's indexed to the record 83 at paragraph 106. They actually called the loss of the kingdom damages covered property damages. Judge Smith said, again, indexed to the record 253, no, these aren't covered property damages. Then they styled them as bad faith damages, and that's what everybody proceeded on. It was only after the verdict, when the jury found there had not been bad faith, that this issue really, that they really embraced this idea that these are damages for a simple breach of contract. Very problematic. You do not have the record in front of you to even begin to do what they've asked, which is to overturn the trial court's grant of new trial. But you do have in front of you the tools that would be necessary to do the opposite, and here's why. No Arizona court has ever said that an insured can collect consequential damages from a carrier that did not commit bad faith. In fact, when the tort of bad faith was first recognized in the 1980s, the reason the Arizona Supreme Court did that is because if an insurance company breaches a contract, the only collectible damages are the amount owed under the insurance policy and interest. That is it. And they said we need to recognize the tort of bad faith so that we can deter bad behavior. We can give an incentive to do the right thing, because just having to pay what you owe probably isn't good enough here. So they created the tort of bad faith. You see that in Rawlings. You see that in Farr v. Transamerica Occidental Life in the 80s. That's why this was created. And the briefing in the papers, you'll see this is consistent with the majority rule. Most courts have held you got to have bad faith. The only courts that we have seen that haven't, who have said you can collect consequential damages from a carrier for simple breach of contract, are in courts that don't recognize the tort of bad faith. It's an either or. Arizona's picked its remedy. You have to prove bad faith, and here the jury was clear. They did not prove it. There was no bad faith. So here, what can you do to right this and avoid the waste of judicial resources? You'll see in the papers there are several ways. Number one, the court could have granted the motion for a directed verdict either before or after trial on the question of covered. Property damages claim was not covered. Number two, could have granted the motion for a directed verdict or remitted her. You can't get these damages under a simple breach of contract, which is exactly what they told the court to do. It's exactly what they told the jury to do when they spoke of the consequential damages, and you're going to see this extensively. His closing arguments to the jury are detailed in this. He told the jury things like the damages for consequential go to the bad faith verdict line. We can fix it now. Thank you, Your Honors.
Counsel, thank you both for your arguments. You've given us much to think about. We'll take the matter under advisement, issue a written ruling in due course, and we are adjourned.
Thank you.